If you could indicate if you're there and your team, I want to welcome you. The evidence leaders here at M46, our support staff with us, members of the media, and as well as the members of the public at YouTube and 408. Welcome to the next inquiry on this day, the 21st of February, 2023. We starting a new witness today, which will be introduced later by Ms. Ibrahim. Just to indicate that we're starting at this time, we'll start now at 2 up until 5. I got an indication that the witness would not be able to proceed beyond 5, and I will honor that. So as things would be, we're going to have the evidence leader starting between now and 5, and then we pause at 5, continue tomorrow. Tomorrow it's half a day from 10 to 1, and then we have all of Thursday and all of Friday, depending on how we go with the witness. So with that, it's a warm welcome to all of you. I just need to get an indication from Mr. Ngoma and Ms. Mori, if we have the witness with us online. Do we have the witness online? Okay. I'm going to invite Ms. Ibrahim to do the preliminaries with the witness, who will be introduced and would introduce himself. And then after that, we'll start. Ms. Ibrahim.
Thank you very much, Chair. Chair, the witness for this afternoon is Mr. Rodney Mataboge, who the committee will recall was a witness that the committee asked us to invite to appear before it. Mr. Mataboge, can you hear me? Mr. Mataboge, your sound is muted.
Good afternoon, Chairperson. Good afternoon, Fatima. And sorry about the struggle with my connection.
Good afternoon. Mr. Mataboge, can I ask you to switch your camera on, please?
Yes, let me do that. I hope it's on now.
Thank you. We can see you now. I'm going to administer your oath. Sir, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law, you are required to answer fully and satisfactorily all questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading, commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Mr. Mataboge, you will now be required to either take an oath or to affirm that the evidence you are about to give is truthful. You may choose either the oath or affirmation. What is your preference?
I'll take the oath, Ms. Fatima.
Thank you. May I ask that you please raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, sir. Chair, the witness is now duly sworn in.
Thank you, Ms. Ibrahim. Again, welcome, Mr. Mataboge, to this Section 194 inquiry. I'm now going to invite Advocate Bauer to interact with you.
Good afternoon, Mr. Mataboge.
Good afternoon, Advocate Bauer.
Mr. Mataboge, it was relayed to me that before you answered questions that I would put to you, you would wish to say something to the committee. Is that still what you would like to do?
Yes, it is still correct, Advocate Bauer.
Okay, Chair, with your leave, the witness had made this request to do that.
Thank you, Advocate Bauer. Mr. Mataboge, you can go ahead and present what you want to present before Ms. Bauer starts.
Thank you very much, Chairperson, and good afternoon to you and honorable members, as well as the public protector and her legal team. I just wanted to ask on Ms. Ibrahim to make some opening remarks as a witness. First and foremost, I said to her that I wouldn't want to appear here as a witness for either side, for reason that I advanced to her to say, due to the fact that when one appears either on the side of the evidence leaders or on the side of the PP's team, there appears to be a perception that one is a witness for either side. And sometimes it comes with some adversarial attitude from either side when one is questioned. So I even asked that I not make a statement, but come and appear here and answer questions that will be put by either side, which I'll answer to the best of my ability without having made a statement. And further to that, I wanted to also impress upon the chair and the House that as an investigator, I said, which I expressed to even the evidence leaders and Ms. Ibrahim, that as an investigator, I feel very much vulnerable to come and appear here before the committee on the matters that I know that I investigated, because, you know, we have got a problem of whistleblowing and that needs whistleblower that need protection in our society. But having to appear here as an investigator, and it's contrary in a way to Section 6.8 of the PP Act, which says I may be competent but not compellable to appear here. But I wanted to put this across to the chair and the House to say, am I being exposed now to the outside world? Especially because now, if really I have to assist the House, there'll be matters that I'll have to bring forth, which may even indicate my previous investigations under the former PP as well, because I've been an investigator for a very long time. So I just wanted to put this forward. I even said to Ms. Ibrahim to say, would it be possible for me to talk behind, not with the camera on, so that I can be able to answer questions? Because if I'm going to be, appearing here for the whole week, I mean, my face will be shown to everyone for the whole week. And, it's interesting that even colleagues that I met several years ago already calling me to say, we'll be watching you on TV for the next few days or so. So this is my worry, but it doesn't mean I disrespect the process, nor do I disrespect what needs to be achieved. But I just wanted to raise this to say, are we not opening up ourselves as investigators in particular that deal with work that needs to work for the public of South Africa? Now we come and talk about that work and expose ourselves. As much as I need to assist, wouldn't I have been able to assist better when I would have been made to make written responses to questions that would have been put to me, as against appearing here today and being questioned and even being put to the public out there. I just wanted to put this to say, it's not with any disrespect to the House, Chair, but I wanted to put this forward to say, am I not now being part of the precedent that may be there now in the future for us as investigators, be it even in SIU or other institutions, to come and appear and be exposed like this? Because when we started this work, I once said to a colleague, we didn't start this work to become famous. One colleague of mine once said, if she wanted to be famous, she would have been a journalist. We investigate as foot soldiers, we investigate in the background. We don't want to appear and appear to be the ones that run the gauntlet, if you want me to use the word gauntlet. So I just wanted to put this across, but with all due respect, Chairperson, if I'm here to help and I can help as much as possible, but it would mean that I'll also have to reflect on previous investigations, long old investigations that I was involved in the era of the former PP as well. So that's all I wanted to say, but I'm here, Chairperson. Thank you very much.
Thank you, Mr. Mataboge, for those important points you have placed in front of this committee in sharing what would have been your concern and for the committee to know. So we really appreciate that you putting that forward and still be in a position to come and be of value to the committee and assist the committee. The committee is a committee set up in terms of Section 194 and in terms of the rules of the National Assembly. Its mandate is focused on the motion that we're dealing with, and we try very hard to confine ourselves to those. We do not attend to any live cases or current issues, and so from our side, we do want to say we endeavor to protect all witnesses in this regard. I don't think you should feel too concerned about the fact that as an investigator you are now going to be known. It's actually even better that you do this in this way, because even if we're to do it under camera after a rigorous and strict process, the possibility is that some of that would be on social media, and at that point you might not be in control of it. So I think the platform that you are in is a platform of Parliament, and it has got its own measures and processes. So let's welcome you. Thank you for those opening comments you have made, and for placing what would have occupied you before, which you would have raised and still proceeded to come and assist the committee. I want on behalf of the committee to thank you for that. And at this point, I'm going to invite Advocate Bauer.
Mr. Mataboge, so that we're not, so we can just be clear about it. You did raise this with Ms. Ibrahim, and she indicated to you that if you had concerns, you needed to put those in writing to be able to put it before the committee to make a decision, correct?
That is correct, Advocate Bauer.
And you didn't do so, you instead opted to address the committee today.
That is correct.
Okay. I just wanted to be sure so that there's no misunderstanding that Ms. Ibrahim did advise you accordingly. That's why I'm raising it, Mr. Mataboge. Can you maybe give us a little bit, because you haven't provided us with a statement, could you tell the committee about your, when you started working at the Public Protector's Office, your qualifications and your employment history a little bit?
Thank you, Advocate Bauer. My employment history dates as far back as 1985. I'm a law graduate. I graduated in the University of Northwest in the 1980s, late 80s. And I started working in the then former Homeland Ombudsman up until when in 1994, I think 95, we incorporated into the Ombudsman that was then Advocate General in the South African offices in Fisagi. I was a senior investigator from that period up until when in 2018 I became the chief investigator. But I've been through the public protector space or institution throughout all the former PPs, including Advocate Bawa, Advocate Mshwana, Advocate Madonsela, and currently Advocate Mkwebane. So I come from that era of old investigators in this institution, chairperson and the committee and Advocate Bawa. Thank you.
Can I start off by saying, Mr. Mataboge, that you are not the subject matter of any investigation. And although there may be a perception of there's a PP's legal team and an evidence leaders team, I'm not out to solicit anything other than the truth from you in the questions that we're going to be posing to you today.
Yes, I hear that, Power.
Right. Now, you said that you were appointed as a chief investigator, and that was somewhere in the middle of 2018. Would that be correct?
That is correct, Power.
And you were based in what is known as the Good Governance and Integrity Unit at the head office of the Public Protector.
Yes, correct.
And we had previously consulted with you. I think it was roughly the 30th of June last year via Zoom consultation, correct?
Yes.
And you had requested that Mr. van der Merwe be present at that consultation, correct?
Yes, I remember, yes.
And he was so at your request present at the consultation?
Yes, he was present, yes.
We didn't subsequently to consult with you again, correct?
No, we didn't consult again. That's subsequent, yes.
We then sought certain information. In fact, subsequent to that consultation, you were going to go and check for certain documents and information to provide to us. Do you recall
Correct,
that?
yeah. Correct, Power.
And I think it was a couple of weeks after that, I'm not sure of the exact date right now, we then submitted a written request to the Public Protector's Office. Was that provided to you?
What written request, Power, was that?
For information and documentation that arose from the consultation we had with you.
Yes, I remember the CEO at the PPSA asked for some document that we needed to send through to you. Yes, it is like that.
Were you involved in the compilation of the responses and the provision of documents that was provided to us?
Yes, I was involved, even though the Ms. Mviana and the team were the ones who were compiling and sending them across through the CEO's office.
Okay, so let's just talk about Ms. Mvuyana and the team. Can we just understand the hierarchy in your division? You're the chief investigator. Who answers to you?
It's senior investigators as well as investigators and trainee investigators.
Okay, so how many people are there in your unit that responds to you?
There are 9, I think, if I'm correct. Yeah, there are 9.
And one of them is Miss, well, she used to be, but she's now moved to Bloemfontein, I understand. One of them used to be Miss Mvuyana, correct?
That is correct.
She doesn't answer to you any longer.
She doesn't answer anymore, yes.
Right. You then in turn report to a, in the ordinary course, you would report to an executive manager.
Correct,
and if there is a COO in office, the EMs would then report to the COO, who would in turn report to the Public Protector.
That is correct.
Right. And it would be fair to say that you are a very experienced chief, although you may only be chief investigator since 2018, it would be fair to say, would you agree that you're quite an experienced investigator? Would you
Yes,
accept that?
yes, I can accept it.
And there have been certain specific and special investigations that the public protector has specifically designated to you. Would you agree with
Yes,
that?
I agree with that, but it didn't start now. Even then, even the previous era, that happened as well.
Yes. So let me say, I don't have knowledge of what happened during the previous public protector, and I'm looking at what is in the scope of the motion before this committee. So if you wish to add anything from what had happened previously, please do so. I just don't have the knowledge, and we haven't consulted at length about those things. So if I only ask you about the current PPSA, it's for that reason. In the investigations that had been designated specifically to you, that would be the investigation in respect of the relating to the alleged breach of the Executive Ethics Code by Minister Gordhan and what we shall refer to as the SARS unit. That would be one of those investigations, correct?
That is correct.
Fine. A second one of those investigations would be the one relating to Mr. Ivan Pillay and the pension that had been afforded to him by SARS.
That is correct.
The third one that I'm referring to would be what's known as the Bosasa or the CR17 investigation.
That is correct.
Right. The fourth one that I refer to would be the second Vrede report.
That is correct as well.
Right. Now, Mr. Mataboge, as I have it, and correct me if I'm wrong, you were not involved in the first Vrede report that had been reviewed and set aside by the court and which forms part of the motion before us, but you were the chief investigator in relation to the second Vrede report.
That is correct.
Right. Now, if I just to start off so that we get this clear, Shepherd, could I just ask you to put the motion on the screen? And apart from your experience as a chief investigator, I seem to recall that you told us that you had top secret clearance and you thought that that was one of the reasons why you had been given these investigations. Do you recall that?
I recall that, yes.
Okay.
Just a pause before you proceed. Mr. Mataboge, just to ask you to reposition yourself a bit so that we don't want to think that you are sinking where you are, so that we can see your shoulders at least. Yeah, now we see you. Thank you very much.
Is the chair sitting in chair?
Thank you. No, go ahead, Advocate Bauer. Just try and lift it up again so that we can at least see from the shoulders.
The chair.
Yeah, it's so just like this chairperson who is speaking.
That's why it goes, chair. That's where it ends.
Okay, okay. So we'll see what we can
front.
do next. Okay, we'll see what we can do. Advocate Bauer.
Right. Mr. Mataboge, just tell us that you are able to see the screen that comes up. I just want to be sure about that.
Yes, I can see it, Advocate Bauer.
Right. So you would be aware that there's a motion before this committee of Parliament. Have you had an opportunity to study the motion?
No, I didn't have a chance, Advocate Bauer. I haven't studied it.
Okay, so let me take you through it in some detail. Well, generally, the charge one relates to the South African Reserve Bank case, which is the commonly referred to as the CX and the ABSA matter. Did you have any involvement in any capacity in that investigation?
No, not at all, Advocate Power.
And you can answer whether this relates to the current PP or the previous PP. Would the answer still be the same?
I wouldn't know when did this one start for me to tell if it started and ended with Advocate Mkwabane and it started before. I wouldn't know that.
Okay, so let's go to charge 2. Sorry, you're just going to have to scroll down. Charge 2 relates to the Vrede Dairy matter. And I'd already put the question to you that you were not involved in respect of the compilation of the first report.
Yes,
Right.
that is correct. I was not involved.
Were you involved in the litigation which ensued consequent to the first report at all?
Not at all, Advocate Power.
So your involvement started, can you remember when it started?
My involvement started when there was a request by Parliament for reinvestigation of the role of the politicians in the Vrede Dairy project. And then the matter was then given to my team to investigate afresh on the basis of the involvement of the politicians.
Right. So let's go down. The second charge relates to misconduct. The third charge emanates in respect to incompetence arising from the first and second charge. So if you haven't been involved in either the ABSA or the Vrede Dairy matter, you wouldn't have knowledge of any incompetence arising from those matters either, would you?
I wouldn't, Advocate Power.
Okay. I'm going to come back when I talk to you about the second Vrede Dairy, about the first Vrede Dairy, but we'll deal with that later. Okay, so let's go up to charge 4. Mr. Mataboge, the charge 4 is a question of, let me read it to you. The Advocate Mkwabane is guilty of misconduct in that Advocate Mkwabane has intimidated, harassed, and or victimized staff. So let me stop there. Have you ever been intimidated, harassed, or victimized by Advocate Mkwabane?
No, I've not been victimized, Advocate Power, at all.
And can we maybe just answer the question? I put you 3 propositions just so that the record has it complete. So the first proposition is, have you ever been intimidated?
No, I've not been intimidated, harassed, or victimized by Mkwabane during my work.
So on the second component of the charge, it relates to alternatively, she has failed to protect staff in the Office of the Public Protector from intimidation, harassment, and or victimization by the erstwhile CEO of the Office of the Public Protector, Mr. Vusi Mahlangu. Have you in any way been intimidated, harassed, or victimized by the erstwhile CEO of the Office of the Public Protector?
No, Advocate Power, I've not been intimidated, nor harassed, or victimized by the erstwhile CEO of the PP, Mr. Vusi Mahlangu.
If I take this a step further, do you have personal knowledge of any intimidation and harassment and or victimization of any other person by either the Public Protector and or the erstwhile CEO of the Office of the Public Protector, Mr. Vusi Mahlangu?
I wouldn't say I know, because in the corridors, there'll be people who would be saying they've been given Audi letters, or they were Audi letters that were coming their way from the former CEO, but I never had any direct, sight and knowledge of that, other than hearsay in the corridors.
Right. And from the Public Protector herself, do you have any knowledge of personal knowledge of that in respect of any other person?
No, I wouldn't have any.
Okay.
I don't have
So
any, in fact, yes.
So let's move on to charge 11. Charge 4, number 11. Sorry, Shepo. Okay, then it relates to she has committed misconduct by and who demonstrated the incompetence in the performance of her duties by 11.1. I'm going to give you an opportunity to comment on this, but Mr. Mataboge, you are not part of management at the Public Protector's Office, are you?
We've got what we call expo. We also have got what we call what is it? A senior management level, level where we meet as senior managers. So we've got different levels. So I'm part of management, but not the executive authority management level of EMs, executive managers and CEOs. I'm not at that level.
Have you at any stage acted as an EM?
No, not at all. Never.
Okay. So if you don't want to answer any of these questions, feel free to do so, but I'm going to put them to you and then you can decide how to respond. So the first question, Shepo, just go up. It says, Advocate Mkabane has committed misconduct by and or demonstrated incompetence in the performance of her duties by, and the first one would be failing intentionally or in a grossly negligent manner to manage the internal capacity and resources of management staff, investigators, and outreach officers in the Office of the Public Protector effectively and efficiently. Do you have any comment in respect of that?
No, I don't want to comment on that because I'll be expressing an opinion that may even be ill-informed. I don't have any comment.
Failing intentionally or in a grossly negligent manner to prevent fruitless and wasteful and unauthorized public expenditure in legal costs.
That as well, I don't have a comment there.
Failing intentionally or in a grossly negligent manner to conduct the investigations and to make decisions in a manner that ensures the independent and impartial conduct of investigations.
Here as well, I don't have a comment.
Now we come to 11.4. By deliberately seeking to avoid making findings against or directing remedial action in respect of certain public officials, while deliberately seeking to reach conclusions of unlawful conduct and impose far-reaching disciplinary measures and remedial action in respect of other officials, even with such conclusions and or measures and or remedial action manifestly had no basis in law, in fact.
I don't want to make a comment. As I say, I will be expressing an opinion that may not be well founded, perhaps.
If you're finding it, okay, let me rather go down, Shepo. Then there's certain documents or cases to which is referred to in support of the aforesaid charges that I put to you. And if we go down, go up. Right. When we look at the court case in the matter of the President of the Republic of South Africa versus the Public Protector, that would be the Busasa related case, correct?
That is correct, yeah.
Right, so we'll come back to that because you've been involved in that report. Let's go down. The court papers in the Public Protector v. Gordon, the constitutional court case, that would emanate or originate in the investigation, or both of them in the investigations relating to, can we call them the SARS unit case and the Pele pension case? Do you agree with that?
Correct, Arwin. Yes, correct.
Okay, so if we then go further down to the next page, there's an additional document that comes in for further information to the panel that was put before the panel. So let me just do this so that we can narrow down what we're going to be talking about. Go down, Shepo. Right. Okay, go down. There's certain orders that's been given in the Vrede Dairy matter, but you were not involved in that. You've told us, stop for a moment. That's the, in 5.2, there's reference to the judgment and order of the High Court in the matter of the Commissioner of SARS v. Public Protector. Mr. Mataboge, that is the case in relation to dealing with a subpoena where the Public Protector's Office sought to subpoena personal information relating to taxpayers from SARS. Did you have any involvement in that matter?
Not at all, Arwin Bauer.
I'm not going to hold you to it, but you might have had some involvement to the extent that it may very well have crossed over into one of the cases or the investigations you were involved in.
No, this one I even know who of the team members investigated. He was not under my supervision, and there was no spillover or overlap into the other SARS matters at all. There was no overlap.
Okay. Right. So on the litigation, you would have had no involvement at all.
Yes, not at all.
The next case relates to the GEMS matter, the government employee medical schemes.
That as well, I was not involved at all.
Right. So that takes out 5455. 5.6 relates to the Financial Sector Conduct Authority matter, the FSCA matter.
That one as well, I was not involved.
Okay, let's go down. Then there is the matter in the Constitutional Court involving Basani Baloyi. Did you have any involvement in the matters relating to Basani Baloyi?
Not at all, not at all. With power.
At some point, you did answer to her when she was the COO, correct?
Yes.
Right. 5.8, that is the litigation in respect of the SARS unit matter, the Gordhan v. Public Protector matter, correct?
Yes, correct. That one I was involved.
Right. So the next one, also, there was an interlocutory application in the first instance, and then there was the full review application. Correct?
That's correct, yes.
Right. So now we've gone through the stuff relevant to the motion. Where you are involved in investigations, it relates, if we summarize it, to the Pillay pension case, the matters relating to the SARS unit, and the CR17 Pusasa investigation. Correct?
That is correct.
So we'll deal with that as we go along. Now, if we start off with Minister Gordhan, in talking to people at the Public Protector's Office, there are let me put it like this, there's a higher than average number of investigations embarked upon by the Public Protector's Office in respect of Minister Gordhan. Would you agree with that?
Yes, I would. And then even expatiate if need be.
Yes, you're welcome to. Mr. Mataboge, if at any stage you wish to expand on your answer, please feel free to do so. Don't be restricted in any way. Sorry, Chair, I'm not doing your job. Okay.
Yes, it is correct, but the investigations come as a result of EMEA, what we call EMEA complaints that come from members of the executive, which compel the Public Protector to investigate. She doesn't have a choice not to investigate them.
Well, Mr. Mataboge, that's not entirely correct, but let me talk to the ones you were involved in. So the SARS unit investigation had two components to it. One was the EMEA complaint relating to whether he did or did not misrepresent an answer to Parliament, and second.
Just a pause, Advocate Bauer. Advocate Mbofu.
Yes, no, I just want to understand what's actually going on. Is Advocate Bauer giving evidence when she says, when she puts to the witness that what the witness is saying is not correct? Or is she putting a version? On what basis does she contradict the witness's evidence?
Thank you, Advocate Mbofu. Advocate Bauer.
If you would allow me to complete the question, I want to put to the witness what the investigations were in respect of Minister Gordhan, and then we can work out what was EMEA and what was not EMEA, because the explanation given by the witness, I'll take back It's not entirely correct because I don't think it was the intent of the witness to in any way give information. So if that's the part, then Advocate Mpofu, I take back the preface and let me just say, let me take you through what I have as the investigations in respect of Minister Gordhan, and then
Okay,
we can
so
work out.
let's then just watch the space, Advocate Mpofu. I will allow you back later if you need to. Advocate Bauer.
So, do I need to repeat the question, Mr. Mataboge?
Through which I thought I answered the question, Ruth Bauer, when I said all of them are EMEA, that compulsory for a PP to investigate. If I may even go further to say, even if there were some that were not EMEA, but the complaints came from a member of the executive, even though some elements thereof were not really on the violation of the ethics code, but they were all in the one complaint. Thank you.
Right. Can I check with you the following? There was a complaint that had been lodged by a Mr. Leers in 2016 relating to South African Airways. Were you involved in that matter?
No, I wasn't involved in that matter.
Okay. So I don't understand. Let me take a step back. EMEA complaints can only be lodged by members of parliament, correct?
It is correct, Bauer.
Right. So if the complainant is not a member of parliament, then it is not an EMEA complaint.
Yes, it's not. We even if because some people make mistakes by citing the ethics code, but we advise them to say we'll investigate in terms of the PP Act, not in terms of the code, because they are not allowed to lodge in terms of EMEA.
That's correct. Okay. So there'd be so in the investigation in respect of what I put to you was the SARS unit investigation. The complaint received was twofold. One came from a member of parliament and one came from an anonymous complainant. Correct?
That is correct.
So a part of the complaint related to a breach of the executive ethics code, and the other part of the complaint was numerous complaints, only some of which formed the subject matter of the SARS unit report. Would that be correct?
That is correct, Bauer.
The PP in the report indicated that there are a number of other complaints which would stand over as such for subsequent investigation.
That is correct.
Right. And can you tell us what happened in respect of that subsequent investigations?
The subsequent investigation is still ongoing. It's currently about to be finalized, but with the challenges that we have around Section 6.9, we are taking advice on that as an institution, because the challenges that related to the Section 7.9 implications is also affecting that complaint as well.
So just so that we're all on the same page, the challenges in respect of 6.9 relates to the jurisdiction to investigate a complaint that is older than 2 years and the necessity to show special circumstances when such investigations are conducted. Are we on the same page, Mr. Mataboge?
That is correct.
Right. There is one investigation that emanates from the report that was completed. Is that the one, and correct me if I'm wrong as to whether it emanates from this report. It's called the BB&D investigation. Was that a different?
Yeah, it's a different complaint, that one that came from a member of the public. It was not an EMEA, that one.
No, it wasn't. It didn't arise from any of the complaints listed in this report.
No, it didn't.
But it also involved, I think it involved Mr. Pillay. Did it involve Minister Gordhan as well?
Yes, it did involve several former employees of SARS, because it dates back to 2015 or 2007, thereabout, when that program, modernization program, was was procured.
Right. And were you involved in that investigation?
Yes, I was involved.
Okay. So that wasn't an EMEA complaint, was it?
It wasn't an EMEA.
Then there was a complaint lodged in 2019, which was done by a member of parliament relating to the irregular appointment of the Mango CEO relating to SAA. Were you involved in that complaint?
Yes, I was involved.
Is that investigation completed?
Yeah, it's completed quite some time back, I think 2 years old now.
Okay, and what was the outcome? Can you tell us?
The outcome, there was nothing that was found to be substantiated, and there was a closing report issued in that respect.
In the one I referred to you earlier on, that was submitted by a member of the public relating to SAA, were you involved in that investigation as well?
The liaise one. The one that you
liaise-
mentioned, I said I was not
Yes.
involved there.
That's sorry. I must ask Ms. Mvuyana about that when she comes, right? Then there was a complaint lodged by a member of the public in respect of a failure to investigate relating to Denel. Were you involved in that complaint?
No, not at all.
Okay. Then there was a complaint lodged by a member of the public in respect of the breach of the code relating to Minister Gordon's alleged abuse of power to benefit a member of the judiciary. Were you, are you involved in that?
Yes, it was an OCJ, we call it an OCJ. It was related to the Chief Justice, isn't it? Are you referring to that one?
It's the one relating to Judge Daya Pillay.
Yes, I was involved in it.
And what was the outcome of that?
The outcome of which was not substantiated in terms of our language, and it was closed as not substantiated.
Okay.
The closing report was signed and then issued to Minister Pravin Gordhan.
Right. So just that we all understand when you say not substantiated, in other words, you don't find any unethical.
So just a switch on for Advocate Bauer. Advocate Mpofu?
Apologies, Chairperson. What has this got to do with this inquiry? Whether, but judges and Pillay and what have you?
Yeah, no,
Advocate Bauer?
Chair, it doesn't matter whether it's Judge or Pillay. I was not going to the judge, but the witness couldn't recall the name of the report.
No, that report. Sorry.
No, Advocate Mpofu, we started off with a proposition where the witness said, when I put the witness a proposition that the minister was subject matter of more investigations out of the Public Protector's Office, and the answer given was because it was the Executive Ethics Code. I'm now reflecting on what those investigations were, and we can then see how many of them was Executive Ethics Code and how many were not.
Yes, but thank you. What has that got to do with this inquiry?
Minister Gordhan is the subject matter of 2 of the 3 reports that do form the subject matter of this inquiry that this investigator was involved in.
Chairperson? Sorry,
Okay.
sorry, Chairperson.
Okay.
I don't want to, through you, Chair, I don't want to have a dialogue. Can I talk through you, Chair?
Go ahead.
Yes. Thank you, Chairperson. Well, I'd like you to rule that this issue is completely irrelevant. The witness has clearly said that whatever it was, the public protector had no choice but to do investigations because there were complaints. So that answer covers whether it's EMEA or non-EMEA. The public protector responding to complaints. That's the first thing that the witness said. So unless if that answer is being contested. Number two, I do appreciate that the Minister Godan is the main person in these investigations, but the committee has ruled that Minister Godan's evidence is irrelevant to this proceedings. So, you know, we can't have it both ways. If we're going to spend the whole afternoon on Minister Godan, when the committee says it's irrelevant, we obviously hold a different view. We think it's very relevant because, as Advocate Bauer correctly points out, he's the subject matter of the investigations. But the stance of this inquiry is that he is not relevant. So we can't have it both ways. Either we don't spend time on him because he's irrelevant, or we spend time on him because he's relevant. If he's relevant, then he must be called as a witness as well. Thank you.
Okay, thank you, Advocate Mpofu, for placing those issues. Maybe from the chair, I'm going to allow myself to just go with the flow and check where she's going with this, and I would be in a position to make a ruling later on it.
Thank you.
Then that's fine. At this stage, I want to get into the Godan matters. Advocate Bauer?
Chair, I'm heading to
No, Chair. I'm sorry, Chair. I'm sorry. I have no problem with you going with the flow as you say you are going to, but we are in the Godan matters. So I don't want you to say we won't get into the Godan matters. The issue is that we are in the Godan matters. I was just asking why. Is it because he is relevant, or is it because he's irrelevant? If he's irrelevant, then let's move on to something that's relevant.
No, I was saying, I'm with you. I was saying, as a chair, at this stage, I won't comment on the relevance and irrelevance of Mr. Godan. We've taken a decision on that, and the decision might be more than what you've just put in here. I don't want to get into that point now. That's all I wanted to say.
Okay.
Thank you.
Thank you.
Thank you.
Chair, I'll shoot ahead so that Advocate Mpofu can be. There are several investigations conducted by the PP's office in respect of one individual. The point I'm trying to show through this witness is that a number of those investigations were actually closed, that the PP's office found was not substantiated.
And so, sorry, I'm sorry, Chairperson. Chair, can I please speak through you?
Yes, please go ahead.
Thank you. Yeah, well, so if a few or 7 or 1,000 of those investigations were closed, what is the relevance of that to this inquiry?
Chair, the relevance of this inquiry is that there were investigations that were investigated and that was found to be a case, and they went on, and there was a number of investigations that was closed. So if there's a perception that's been created that in every investigation that has been brought against Minister Pravin Godan by the PP's office that went on and on and on, that's not borne out by the cases, Advocate Mpofu.
And
some of them were closed. The PP found there was no case against him.
so what? The issue is, what is the relevance of that? I know that happened. Let's say it happened 1 million times.
Chairperson, please don't allow this conversation.
Yeah.
Okay, Honorable. I will let Advocate Mpofu conclude. And
yes, sorry, Chair. I apologize, Chair. No, Chair, let me just try and articulate this once and for all. I hear everything that Advocate Bauer is saying, and I'm saying assume that there were 100 million investigations against Mr. Godan that were found to be unsubstantiated or whatever, or closed. I'm not questioning that. I'm asking about relevance. I'm saying that relates to what, as far as this inquiry is concerned. If the witness says yes, there were 100 million investigations closed, it will show what in relation to this inquiry.
Okay, thank you, Advocate Mpofu. Honorable Heron, before I go to you, Advocate Bauer.
Thank you, Chair. I'm also trying to understand how the evidence that's been led relates to the charges. And maybe Advocate Bauer can make that clear.
Thank you.
Advocate Bauer.
Chair, there's 11.4 of the charges. And 11.4 of the charges says that Advocate Mkabane has committed misconduct and or demonstrated incompetence in the performance of her duties by deliberately seeking to avoid making findings against or directing remedial action in respect of certain public officials, while deliberately seeking to reach conclusions of unlawful conduct and impose far-reaching disciplinary measures and remedial action in respect of others, even where such conclusions and or measures and remedial action manifestly has no basis in law or fact. One of those relate to Minister Gordhan in respect of the two cases. But there are other cases in relation to Minister Gordhan that she didn't do that. In other words, she closed it because those cases had no merit.
Just mute your mic, Advocate Mpofu.
Oh, apologies, Chair.
Okay. Advocate Bauer, conclude.
Mr. Mataboge?
Just maybe before you proceed to Mr. Mataboge, just Advocate Mpofu, just for your own protection there and the team, because you are in one space. So when they whisper to you, we can hear them.
Oh,
So,
I see. No, thank you, Chair. It means there's another device. Yeah, it
just
means
make
there's
sure that
another
you
device
mute.
as well.
Okay.
Yeah. Thank you, Chair. Thank you very much.
We can't stop them from whispering to you, but
Yes.
so when we all hear that, then it just gives another picture.
No, for sure. No, the whispering thinking we're all muted. Yeah, no, we'll mute, Chair. Thank you.
It's fine. Thank you. Advocate Bauer.
For the record, I didn't hear anything, Advocate Mpofu. Mr. Mataboge, we were on the investigation of the breach of the ethics code in respect of the benefit of a judge. You indicated you were involved in that investigation and it was closed as unsubstantiated, correct?
That is correct, Advocate Bauer.
Then there was a further complaint, which I think comes from a member of the public. I'm trying to refrain mentioning people's names, but the investigation related to what was termed by the complainant to be market influences, which drove the former president to remove the then finance minister Van Rooyen and replace him with Minister Gordhan. Were you involved in that investigation?
No, I wasn't involved in that one.
Do you know what the outcome was?
No, I don't remember.
Okay. Then the other one I have is also looks like it was a member of the public, where they alleged, amongst others, corruption, irregular procurement processes, violation of the PFMA, nepotism, and racial application of the disciplinary code since 2008. Would that be the BB&D one?
No, the BB&D one related to the modernization program only.
Okay.
It wouldn't be that one, and I don't know which one is that. I was not involved.
You were not involved. Do you know if that one is completed?
No, I wouldn't know. No.
Okay. And then the other one that I have is obviously the one relating to the Pillay pensions case, where the investigation wasn't directed at Minister Gordhan specifically. Am I correct?
Yes, correct.
Right. Are you aware of any other investigations?
No, these are the only ones that I'm aware of, and that fell within my purview.
Okay. Now, as the chief investigator, you would also be aware that all the investigators and the executive managers are meant to have top security clearance, correct?
Correct, Advocate Bauer.
You also, if I recall, you deal with quite a few of the important matters, and you mentioned to us that since you've taken over as chief investigator, dealing with some of the high profile cases, the leaks in respect of these investigations had I think become something of the past. Would that be
Yes,
a correct?
this is what I said, and that was the observation I made. Yes.
Do you wish to add anything to that?
Yes, I would, except to say that it was because of what the PPs are trying to deal with the situation of leaks by having as few people involved in the crucial and sensitive and investigation that involved especially the executive authority. The lesser people you had, the more you could hold them to account. And maybe that helped in my view, if I may express an opinion here, Advocate Bauer. Thank you.
But that also had the effect as chief investigator, Mr. Mataboge, approximately how many files do you carry that you have to oversee at the GGI?
That became quite a number, I must admit.
Okay. And in some of those, you would be part of the command chain to which you would account to the executive manager and the CEO, correct?
That is correct.
And then in others, as chief investigator, because of the PP's measures, you would be accounting directly to the public protector.
That is correct. That with those that should, like OSASA, allocate to me to deal with particularly. Thank you.
So would that be BUSASA? Would that be the SARS Unit 1 as well?
Yes, the SARS Unit 1 as well, but that was first handled by other people before it came to me. Before I could be appointed the chief investigator, it was handled by some other team members. Yes.
And after it came to you, did you report to anybody else? Or did you report to the PP?
The reporting channels were still they were still the same. PP would from time to time sometimes want me to report directly or come directly to have a meeting with her, but the reporting channels were still there. Even memos that were being submitted would go through the CEO, not the CEO, the COO as well as the executive manager before they reach the public protector.
So if you submitted the section 7.9 or the report, would you have submitted it to the EM and the CO in the normal chain? Would you submit it directly to the PP?
No, it would go through the EM and the COO, and it will go to the PP.
By the way, in any of the investigations that had been conducted, that you had been involved in respect of Minister Gordhan, they'd either been unsubstantiated or they'd been reviewed and set aside by a court. Am I correct?
Can you repeat the question? I would bow.
In respect of any of the investigations that had been conducted, in respect of which you had been involved in, involving Minister Gordhan, they had either been unsubstantiated or they had been reviewed and set aside by a court. Would that be correct?
Chairperson?
Not all of them, I think.
Okay, Advocate Mpofu.
Yes, okay, well, I think the witness has come to the
Has responded. Yeah, thank you.
Advocate Bauer, because earlier she had herself had elicited an answer that there's an investigation that's still even in the pipeline. But anyway, I think the witness has resolved it. Thanks. Thank you, Chair.
Thank you, Advocate Bauer.
Chair, I don't know what answers the witness is going to give because I hadn't at length consulted with this witness. Mr. Mataboge, I probably phrased the question wrong. I'm talking about the investigations that have been completed, not the ones that are still in the pipeline. of the ones that have been completed, right? They've either been unsubstantiated or they've been reviewed and set aside by the court. Are there any which have not been, that fall into any of those two categories?
I don't know them
I
all
think
now.
you're
I'll have to check.
Sorry, we didn't hear you. You were muted.
I'm saying that then I'll have to check on my records, because what you're saying is one in the specific ones that were set aside and those that were not substantiated versus those that went through or that were successful. I'll have to check my records if you may indulge me on that one.
Not a problem, Mr. Mataboge. I accept that we wouldn't have consulted or prepared for the questions I'm asking. So if with leave of the chair, we could maybe have a running list of stuff that you're not able to answer. And when you do come back the next day, we could maybe then just pick up those questions if you then have an opportunity to check on them. Would that work, Mr. Mataboge?
Yes, I can check them, Power.
Okay, just. Now, in the greater scheme of things, investigators, and I thought you were saying this to us in your opening address, you are the foot soldiers of the PPSA, and that ultimately the reports are signed off by the public protector. Is that a correct understanding?
Yes, that is correct, Power.
Right. And effectively the direction and the contents of the report are determined by the public protector.
Not really, because as investigators, we go to direct the investigations and then the public protector to then advise us and guide the investigations to their conclusions. It doesn't mean they all the directions are coming from her.
But would it be fair to say, and I think I saw it written somewhere that you've characterized it that she is diligently involved in investigations of matters from the start to the end? Would that be correct?
That is correct, because when we submitted, for instance, where the Executive Members Ethics Act is involved, we have to submit the investigation plan to her. We're going to submit the document request letters through the normal channels through to her. So in such instances, she'll be involved up to the end of an investigation.
And she would provide continuous inputs to direct the course of the investigation throughout it.
Yes, correct.
And she would assist you in providing case law or other conclusions and debate issues with you while you're busy with the investigation.
Very much so, Power.
And do you find that you're able to persuade her to a different viewpoint, to a different conclusion, to one she may be inclined to reach? Or is there or are you not able to?
On more than one occasion, we managed to do that as a team, not even myself in particular, because when we submit to her, we submit with the interpretation and application of the law to the facts, and we motivate to her, and we sit and debate, and we are able to persuade her on a number of occasions. Yes.
And you're not the first one that says that to us, but others have also said that there are times when she's determined that that is the correct path to follow. She makes the decision, and that's the direction that the PPSA takes. Would that be correct as well?
That would be correct as well, because at the end of the day, she's the one who appends the signature, if I may say. And the appending of a signature should obviously be with her being satisfied with what she signs for.
And there is nothing wrong with that, Mr. Mataboge. You're correct in pointing of she signs off on it, and she must be satisfied with the contents of the report. Is that how I understand what you're saying?
That is correct. And if I may substantiate that, then I'm going to be going back to what I had put earlier on to say, where I'm coming, even in the past era of the previous PP, you'd be told that the PP is the one that the report is the PP's report, it's not your report. And we were normal, I mean, we were accepting that as normal to say at the end of the day, the final weight comes from the PP as the signatory.
Okay. Now, I want to test, I mean, you two are a lawyer, Mr. Mataboge, correct?
Yes, correct.
And in fact, most of the investigators, if not all of the investigators at the Public Protector's Office are lawyers.
Yes.
Different, some may have practiced, some may not, correct?
Yes.
Now, as a basic proposition of law, would you agree that the jurisdictional facts to bring a law into force must have been complied with before it has legal efficacy? In other words, if it's legislation, it must have been adopted by Parliament and it must have been signed by the President before it has a force of law.
Yes, it is correct.
And in a similar way, if it's something that comes out of a local authority, it must have gone through the municipal council, fulfill the jurisdictional facts before it's accepted as a legal instrument emanating and binding on the local authority. Would you agree with that?
Yes, I do.
And regulations must be gazetted. They must be signed off by the relevant authority before they become force and effect as well.
Correct. Yes, Advocate Power.
And you would also be aware, I think you referred to it as high profile matters and others refer to it as political matters. They are matters of utmost importance to the country. Would you agree?
Yes, I agree, but not all of them, they are political matters. High profile for us as an institution would mean even complex, like we call them conduct failure, complex relating to tender irregularities and so forth, not necessarily political matters.
Okay, so there's a distinction between political matters and high profile matters. Some may be both and some may not.
It's correct, Arubao.
And some of the EMEA complaints involve members of the executive in the National Assembly. It would also involve members of the Parliament. Would you agree with that?
Yeah. Yes, I agree.
And in a number of these cases, if not all, they have very serious consequences for not only the subject matter of the investigation, but also to the country.
Yes, I agree.
You'd agree with that?
Yes.
Right. And so when very serious findings are made by the Public Protector's Office, it has an impact on public confidence in our elected officials in some way or another. Would you agree with that?
Yes, I do.
And this is in some ways makes the Public Protector's Office a very important cog in our democracy because of the wide ambit of her powers and because her remedies have binding effect. You agree with that?
Correct. I agree.
And that places a huge responsibility on the Public Protector because those reports become very important once they're issued. In other words, you would expect that the preceding process would have been meticulous, thorough, reflect a high level of competence. Would you agree with that?
Just pause, Advocate Bauer. Advocate Mbofu?
Yeah, I must object strongly to this. I don't know. It looks like Advocate Bauer is giving evidence now, and she just expects the witness to say yes, yes, yes. So I don't know who's giving the evidence, and the witness is just being used as a prop to say yes to Advocate Bauer's evidence. So unless if whatever she's putting comes from some source and she must enlighten us what that source is. If it doesn't have a source, then the source is her, and that's not allowed.
Thank you, Advocate Mbofo. Advocate Bauer?
At any stage, Mr. Mataboge can say no, he can elaborate, he can disagree. I'm not using him as a prop to say yes. I'm sourcing and understanding what the importance is of the reports on which has been worked with. Now, I'm not for a moment giving evidence, and Mr. Mataboge must be free to disagree with me. He said that to him up front. He can elaborate on it in any way.
Yeah, Chairperson.
Yes, Advocate Mbofo.
Yes, no, that's exactly the problem I'm complaining about. Mr. Mataboge is not here to agree or disagree with Advocate Bauer, as she says, that he's free to disagree with her. She has no role in this except to be an evidence leader. So Mr. Mataboge or any other witness is not here to agree or disagree with her. She's nothing to this commission. She's just a legal practitioner like me. And when I put propositions to witnesses, it's because I'm putting them because my client has put them to me, but I'm equally irrelevant to these proceedings. Otherwise, so no witness is there to agree or disagree with Advocate Bauer or me, because we have nothing to do with this. Thank you, Chair.
Thank you, Advocate Mbofo. Let me note your objection, and then I will travel the journey with Advocate Bauer and see where I need to intervene.
But Chairperson, can I just say something? I'm sorry, I don't want to waste your time. I don't understand your remarks. When I'm asking for a ruling on an issue, and you tell me you're traveling a journey or going with the flow, or those kinds of indistinct remarks. Yeah. So what does that mean when we're traveling the journey? Does that mean she can continue asking the witness to agree or disagree with her, or does it mean she cannot?
Thank you, Advocate Mbofo. I said I have noted your objection, and I'm asking Advocate Bauer to interact with the witness further. I will be watching if there's anything untoward in terms of what she's doing.
Okay.
Go ahead,
Thank you.
Advocate Bauer.
I'm not going to get into a debate with Mr. Mataboge. The proposition I would put to you, or I had put to you, given the importance of the reports issued of the nature we were discussing, it's not unreasonable that when these reports are published, that the preceding process is meticulous, that there's a high level of thoroughness and competence in those reports. Would you agree with that?
Yes, I agree to that. I could even take it further to say, and that's all that we do by all sincerity, and the PP also does that with us, maybe as a way in the eyes of the review judges. We fall short somewhere, but we do our best in the circumstances. Thank you.
That's fair comment. Can we also say that underscoring what you do, you endeavor to be fair, and that fairness must be must extend to both to the complainant, to the witnesses, and to those who are implicated in your reports. That underlies the work that you do. Correct?
Yes, yes, that's exactly.
And so there must be no taint on the report that there's been any predetermination of any outcome. You wouldn't, as a chief investigator, want that perception to be created, correctly or wrongly. Would you agree with that?
I don't know how to answer, but in all sincerity, we do our best. We work without fear, favor, or prejudice, and I wouldn't take it any other way except to say that we do our best as PPSA, notwithstanding the comebacks, as I call them, comebacks.
Mr. Mataboge, can I take you to the SARS report? I'm going to ask Shepard to put it on the screen. It's in file E, bundle E, item 4, page 216. It's PG1.
No, it's a PDF. It's a PPSA.
It's PG1.
PG1. Page 216.
216 of the PDF. So if you just click on 216. Oh.
No. Item 7. Bundle in item 7. And then in item 7.
Go to item 4.
Okay. See. And then there go to page 216. Yeah.
Okay, so we 5.8.15, which one sees on, and I'm going to talk before we get there because you would be 5.8.15. It is the statement that one finds in almost all of the reports that I've come across. Mr. Mataboge, you'd be very familiar with it. So whilst they're finding the page, it's the paragraph that says the public protector is not a passive adjudicator between citizens and the state, relying upon evidence that is placed before him or her before acting. His or her mandate is an investigatory one requiring proaction in appropriate circumstances. Although the public protector may act upon complaints that are made, he or she may also take the initiative to commence an inquiry and no more information that has come to his or her knowledge of maladministration, malfeasance, or impropriety in public life. You're familiar with that, Mr. Mataboge?
Yes, I'm familiar. It comes from the maid and guardian judgment, I think.
5.8.1.5, right?
Yeah, page 3.
Yeah, maybe let's wait for it and see all of us.
And I want to paraphrase that into a simpler English, and you tell me whether that is how it's understood as well. It means that the public protector doesn't only rely on information put before her, but she has to go out, be proactive, and take the initiative in respect of complaints to commence an inquiry or to advance an investigation. Would you agree that that's a appropriate encapsulation? And even the last part says, sorry, Mr. Mataboge, let me give you an opportunity to answer.
It couldn't have been said better, but as I was saying, that is from the maid and guardian judgment, where in that case, the PP then was criticized in one of the cases. But this is exactly what we do as investigators. We do much more as indicted by this phrase, this paragraph.
And so the point is, even when there's information that has come to of a narrow ambit, there's nothing which precludes her as a matter of principle. Let's just talk about the principle and not the detail that would allow her to broaden that investigation in the respect of matters that comes to her knowledge relating to maladministration, malfeasance, or impropriety in public life. That's the quote from the judgment, correct?
Correct, yes.
Okay. So I won't take you into specifics because you're not involved in the CX matter, but one of the issues in that matter relates to the in principle widening of the ambit of an investigation. And this paragraph looks at precisely taking steps to widen an investigation when matters are brought to you. Would you agree with that?
Yes, I do.
Okay. Now I want to take you to paragraphs 5.8.1.8. I think it's just a page or two down.
Yeah. The next
Right.
page.
And that refers to the exact wording in the Mail and Guardian case, right?
Yes.
And the Supreme Court of Appeal has held that the public protector should not be bound or limited to the issues raised for consideration and determination by the parties, but should investigate further and discover the truth and also inspire confidence that the truth has been discovered. And that should underscore every investigation that takes place in the public protector's office. Would you agree?
Yes, I do.
And I am correct. I can't say it as a general proposition, but you do endeavor to put these two paragraphs in just about every report that comes out of the public protector's office. I may be wrong that it might not be applicable to all, but I've seen it several times now.
Yes, it is one of the paragraphs we include in all our reports, and we try by all means to do by the principle, to abide and comply with the principle.
Right. Now, can you tell me what investigation entails as a general proposition?
Come again, Rubawa?
Well, what does investigation in respect of a matter entail? We can talk about generally, and then we can talk about it specifically in respect of the reports. Tell me as a layperson, what must I understand when an investigator embarks on an investigation in respect of a complaint that's being laid at the public protector's office?
I'll try my best, but the investigation will be based on the allegations which are facts that one needs to pursue. But in so doing, one needs to first be informed by the law that needs to be researched on what is alleged, and in order to verify the facts that one has been asked to look into, and also look for the evidence that talk to those facts in order to make some conclusion or some finding before you conclude. But now when you conclude, you have to work those facts and the evidence against the law that is applicable. That will then give an investigation its conclusion, its final report. You apply the law to the facts and the evidence.
Thank you. Maybe on that general explanation, we can pause for 15 minutes and take a tea break and be back at 3:45. Advocate Bauer. Thank you. Just a tea break, Mr. Mataboge. We'll be back at 3:45.
Thank you, Chair. Thank you, Chair.
Recording stopped.
We now back from tea and we resume. Advocate Bauer, over to you.
So, Mr. Mataboge, before the adjournment, we were looking at what investigations in broad term entails. And you were endeavoring to explain that you look at, I suppose, I think you said the evidence, the complaints, the facts, the evidence, and you apply the law to the evidence. Would that be a fair summary of what you said?
No, it wouldn't be. Advocate Bauer. I gave a bit of a background as to the allegations, the facts that come from the allegations, and the research on the legal applicable law, as well as the evidence that would then, at the conclusion of the investigation, the law that would be applied to the facts and the evidence before us.
And so when we come and we look at this evidence, you would have to, let's assume you have a complainant and the complainant brings certain facts to you. You would have to do an assessment of that facts. And if your own investigation shows that there are contrary facts, you would reflect both in your report. Would that be correct?
I don't get the question.
Well, let's assume let me take an example. If the plaintiff comes and the plaintiff says to you, this report I'm relying on for purposes of the complaint that I'm providing to you reflects that the evidence against the person I'm seeking for you to investigate says he is guilty of maladministration. And if your investigation, and during the course of your investigation, you become aware that there are flaws in this report that has been brought out, then you would be obliged as part of your report to raise those flaws in respect of that which the complainant puts before you. Would you agree?
No, I wouldn't agree, except to say that when we get a complaint, before we run or investigate it, we first consult with the complainant and we log the issues that he or she provides as allegations of as facts. Then after we've logged or confirmed the issues and we raise them with the respondent department and we get a response, only when we then do what we call the notice that says the matter is not substantiated, we also show the allegations that are not substantiated, which will then come from the facts that we have provided to us. But where the matter is substantiated, we also show where the facts confirm the allegation that have been brought before us as being founded.
And if the facts that is before you brought by somebody other than the complainant say something differently, then you would reach presumably a conclusion that the complaint is not substantiated. Am I understanding you correct? Sorry, I don't want to mislead what you're saying, but I'm not sure if I got it right.
I think I don't understand the question myself either, because we are talking about the complainants. Now you're talking about another person bringing the facts before us.
No, sorry.
That's where I get confused as well.
The complainant comes and the complainant puts facts before you. That's the first starting proposition. You then go to the shall we call the implicated department, and you ask them to respond to the facts which the complainant puts before you. That would be your second step, right? And if what is put before you by the complainant contradicts, what is put to you by the responding department contradicts what the complainant says, then you would take that into account in the formulation of your report.
Yes, we do advocate power. That's why I say then we issue what we call a rule 41-1 notice, 41 in brackets 1 notice to the complainant to say what you had alleged. We contacted the department, this is their response. And from the look of things, what you alleged is not founded. If you have got further information that you may provide to substantiate on the allegations you made to us, please do so. That is how we then capture it.
And if your own investigations show that there are concerns, or there should be concerns, or there are some form of doubt placed on what the complainant says, other information which comes to your knowledge or attention other than from the responding department, would you take that into account?
Yes, that is why based on the Mail and Guardian, we do not just take in what the department brings to us and regurgitate it or use it as fact and as proof. We also have to consider other facts as well.
Right. So if I understand that, you wouldn't simply summarize the complaint, accept it as fact, and not do anything with any information that refutes that facts. You would conduct an investigation as the Mail and Guardian tells you to do. Am I correct?
You're correct, Power.
Now, when you commence this investigation process, am I correct in understanding it is referred, say it's a GGI investigation, it is then referred to an investigator who then reports to you. It would be allocated to a particular investigator.
Correct, Power. Yes.
So let's take the SARS unit report that was allocated. Let's pick it up from where it was allocated to Ms. Mvuyana. I somehow think she may not have been the first investigator on the matter, but she may have been. The matter lands on her desk as the investigator. And does she become the custodian of the investigative diary?
Yes, she does.
Right. And for the ease of the committee, can you just explain what the investigative diary is?
Come again, Power.
Can you just explain to the committee what the investigative diary is?
The investigating diary is the we call it the life of or the life cycle of an investigation, where whatever activity that is occurring in the investigation or in the file is being recorded. Wherein if you had a meeting, you record that you had a meeting with the Power. If you had a letter that we received from a department, you record it. It's sort of that's why I'm saying it's a life cycle of activities that are in the file.
It comes in a hardcover, and it's usually on the inside of the hardcover of the file. Is that physically where it's located?
Not always, because sometimes the hardcover of the file gets full, and we use we've got loose pages that we also have the same subheading on, and the same activities are written on. Because sometimes the investigation takes longer to run. We may find that we even have 4 such investigation diaries in one file.
Right. Now, in the SARS matter, generally, let's take this. The investigative diary doesn't form part of the Rule 53 record. Would that be correct?
Yes, it doesn't form part of the Rule 53. The Rule 53 are the documents that are inside the whatever letters that we received, the reports and so forth.
Now, when the investigator is to put the Rule 53 record together, how does that impact on the investigative diary?
If you have to put the Rule 52 together, you have to go to the investigator to check the recorded activities of the file, so that if there are meetings, if there are audio recordings that are there, you are able to then know that on this day you had a meeting, so that you must then get a recording for purposes of Rule 53 in preparing the Rule 53. We then have an index and pagination to separate for the Rule 53 documents.
Now, you are aware, Mr. Mataboge, because I've raised this with you before, the investigative diary in respect of the SARS unit is not intact. Have you had an opportunity to check on that?
The investigating diary in respect of what? SARS matter is not what?
The investigative diary in respect of the SARS unit that was provided to us by Ms. Mvuyana is not intact.
Yes, I'm aware.
When we had last spoken, you were going to check on it. Did you have an opportunity to check whether it was an administrative error or whether it was an error that's how it came about?
I think it was an administrative error because when colleagues or investigators continue with the matters, they, instead of recording right there and then on the days that their activities, they put it, they deferred to the next day, and as a result, there becomes some gaps on the investigation diary, and that's how it happens. And they then refer to whatever, if there are emails or recordings, when they then have to do the final report, then they then have to go to the diary and update it, and then sometimes it's always very late, like it happened with the SARS matter.
But it shouldn't, Mr. Mataboge, from what you tell me, the investigative diary is not part of the Rule 53 record, only the attached documents that may be in the file. So how does the investigative diary become missing in this process?
It doesn't miss per se, great power. It's that it's not completed on time, but because the information that needs to be on the investigation diary should come from the records that are in the laptop or the desktop of the investigator. He or she needs to then continuously update on the investigation diary because it's not an internal document in the file.
I'm not sure I understand it. Let me take you to the investigative diary that was provided to me. If you go to item 71 of bundle F, Shepo, and then you go to PDF page 41. F. Yeah, it's page 3180. Okay, if Shepo, maybe go to page 3183. If we look at it, what I think is right. Do you see this, Mr. Mataboge?
Yes, sir, I'm looking at it.
Right, and this is what seems to be the first page, which seems to be handed over to a different investigator that has come in, and it appears to be a takeover from the complaint which was lodged by Mr. Shivambu on the 8th of November.
Correct.
Can you explain the takeover?
The takeover, this one resulted when Mvuyana was on maternity leave, and it had to be reallocated to somebody to run with in the meantime. That's how it happened.
But from the date of the 15th of the 9th, 2021, this is a reconstruction that she does in 2021. Would you agree with that?
This reconstruction is not reconstruction per se. It is the entry for the or the new investigator that's written at the top there. I don't think this is the entry from Advocate Vuyana, because this is when the new investigator that is written there received the file. So there ought to be the same entry in respect of Advocate Vuyana's activities in the matter, in the file, prior to this one.
So in other words, I haven't gotten an investigative diary from Ms. Vuyana at all.
Yeah, that's what it means. Because what she gave you is when the file was already to another investigator. And then she ought to be having her own diaries prior.
And this was the file that was provided in respect of what we asked for, the SARS matter that was uplifted from your office, if you recall, Mr. Mataboge.
Yes, I remember.
Are you in possession of any other investigative diary emanating from Ms. Vuyana in your office?
No, because the file is with her. So I need to check with her so that she must provide with whatever that she may have omitted sending through. That talks to her activities in the file.
Okay. And you haven't checked with her since you've last conversed with us about this?
No, I've not checked with her because she's in the Free State office and she's been sick for some time now.
Okay. And when did she relocate to the Free State, Mr. Mataboge?
I'll have to check. I'm not sure whether it was the beginning of the end of last year, but it's not recent, quite some time, 3 or 4 months.
We had made this request at the end of June of last year. Was Ms. Vuyana still at the head office at that stage?
Yes, I'll have to check. I believe she was I'll have to check.
So that's
Because
the second
I was, if I may say, you recall, I was also
Okay, I think seems to be frozen. Let's take a pause so that we allow him back to the system. Slow tempo on your phone. We'll pause for a few minutes.
Recording stopped.
at the office?
Yes, I'm at the office, Chairperson.
So this generator at that office takes more than 10 minutes. Is that how it works there?
Recording in progress.
That's how it works. We are used to it, Chairperson, that way.
You're used to it that way. Okay, thank you for that.
These days, that's
I
what it
needed that. Thank you. And he was not here when we spoke, so he just put as it is. Thank you. Welcome back, Advocate Bauer.
If I can just ask for the page to be put back onto the screen so that it would assist Mr. Mataboge and my understanding as well. So if I understand what you were saying to me is that Advocate Muntwedi Shabalala takes over the file on the 15th of September 2021 and she details whatever is provided to her on that day as a new file. Would that be correct?
That is correct, Advocate Bauer.
And so if
Even
we
even the documents that she lists there, she lists them afresh, and those documents ought to be in the file, in the old investigation diary compiled by Ms. Mviana.
Okay. If we see, just to be a bit helpful, and we go down, we will see on item number no, if you look at pages 16 to 22, it says memorandum to the CFO regarding the request for Ms. Mvuyana to act as senior investigator dated 13th November 2018. So she was appointed very shortly after the complaint came in, correct?
Where are you? I'm lost.
Maybe the second item from the top that you can see. If you look at the page numbers as it's identified, there we go. It's been colored in for you.
Yes, but this one is an old memo that is for 2018. I wonder why was it here, because it was 2021 that this investigation diary was compiled by Ms. Chabalala Muntwedi. So,
no, but if you look, sorry, Mr. Mataboge, just if Shepard goes right up to the top,
yes.
she takes over this file because there's still components of this investigation pending. So in the first
Yes.
line, she says she changes the reference number on top and she says receive new file with the following. So she details it from the complaint that emanated on the 8th of November 2018 and she goes down. Do you see that? So this would have been the documents that was with Ms. Mvuyana. I'm hoping you can confirm this, but I'll ask Ms. Mvuyana when she comes. That's then taken over by the investigator. And if you go to the second page, the one just after this, you see there's a whole lot of correspondence that we know is involved. She says on the 9th of September, in light of the PP's directive, kindly receive the reallocated file from Ms. Mvuyana for further investigation during her maternity leave.
That is my recording. That is my notes there. It's my instruction to Ms. Muntwedi Chabalala.
And right, and then it says, if you look at the next entry, you would see it says the matter is reallocated to you, and number 2 says liaise with Mr. Mataboge and Nomfundo to give you other evidence responses related to this matter. You must follow up with the information from SARS as per the subpoena signed by the CEO. Mr. Kisvet is yes to respond. Please make follow-ups. And then this is a subsequent investigation. I don't want to go into details. This is not the ones we're talking about, right? But this is the investigation that gets allocated. Now, if we go one page further up to 3182, we see that's a continuation of the listing of the documentation that she had received from Ms. Mvuyana. Would that be, if you go down?
Yeah, this is what seems to be the case. Ms. Muntwedi Shabalala was that jotting or recording all the documents that she found in the file.
Right. So if we and if you go down to the handwritten notes, there's a file presented to Mr. Lamini. Mr. Lamini is probably doing file inspections. Would that be correct?
That would be correct, I believe, not with Baba.
Right. So when somebody does a file inspection, they would do a handwritten annotation, right?
Yes, even the one that were typed in when we deal with them daily with handwritten notes. You don't need to type them particularly.
Now you would expect 110 pages in this investigative file, pages 105 and 106 being the investigation plan dated 11th November 2018. That would be a fair assumption to make, correct?
I'm not sure about the number in that Ms. Muntwedi Shabalala put here, where she gets it from, because I'll have to check, because is that the indexing that comes from her, or is that the number of pages that were in the file? I'm not sure.
Okay, so if you go to the first page, it seems as if to be numbered from number 1, and it goes to the bottom at number 51. I'm at 3183. So it doesn't seem anything more than counting the pages of what there is starting at number 1. Whose initials would that be in the last column?
Ms. Muntwedi Shabalala.
So she's confirming that that's what she's received.
Yes.
Right. And she goes down to the bottom at 51. And then if we go back up to the other page, it starts at 52 to 59 and it comes down to 106. The point I'm trying to make without belaboring it is when this file is provided to me in 2022, despite it having been intact for Ms. Shabalala, Ms. Muntwedi Shabalala to have indexed it. By the time it comes to me in 2022, there are significant documents not provided. What would an explanation for that be? Because we're now way past the Rule 53 record.
This is the file that is in my view, from which the volume 2 investigation was to come. This is not the one that was finalized. This is the document the file that is still needs to be finalized, as I explained earlier.
The file still to be finalized.
Yes, it's not finalized, this one.
Yeah.
Because you remember there were issues that were deferred to volume 2. The other ones were closed along with the EMIA that was reviewed, the EMIA investigation.
I'm aware of that. I think, sorry, Mr. Mataboge, I think I phrased the question badly. Here's my point. On the 15th of September 2021, Ms. Muntwedi Shabalala takes over the file from Ms. Mvuyana. She signs and she receives all these documentation that's there based on what is provided for on the page of the investigative diary. This file is then, we ask for the investigative diary. It is then removed from your office, and the file that is provided to us is 45 pages with a number of documentation removed, including, most importantly, the investigation plan dated 11th November 2018. Now, how does one explain that? Because I'm putting to you that if we look at the date when Ms. Advocate Montwedi Shabalala puts it together, we are way past Rule 53 records in the SARS unit litigation, that can't explain why such a file would now be in tatters.
When you still mention the Rule 53, that's where you also confuse me, because like I said, this is the current file. However, in trying to further clarify, I wouldn't know, because you say it was removed from my office, but should have been removed from Ms. Montwedi and Ms. Mvuyana's office. And with all those documents, I believe, intact and inside, then I'll have to then say, we need to find out from either of the two, or even Ms. Mvuyana when she comes here next week. Because I thought all of those documents that are indexed, it should have been sent, should have been in the file that was sent to you.
Yeah, it was not. But the point I'm trying to make is there would have been file inspections done on this file, surely as well. I mean, they fall under in your division, don't they?
They do. That is why, if you look at the bottom, I was away on my wife's sick leave for a long time, family responsibility. If you look at the bottom, it's inspected by Mr. Dlamini, who was leading the team at the time.
If we look at the pages at 3180, you see that the file is internally transferred from Ms. Motseneng, and on the 14th of March, it's then transferred from phase 2 to phase 3, and the team is allocated. And the matter is now back with Ms. Mvuyana.
I'll have to explain the phase 2, phase 3 process, because when in an attempt to deal with the backlog, this file was part of the backlog. Phases were formed within PPSA to deal. Phases would be a team under phase 1 that will assess the complaint, a team under phase 2 that will draft and check the evidence, a team under phase 3. So the files were taken that way, like this one, given to different phases which comprise of team members. So that is how it was then reallocated to phase 3 team.
Yes. Okay. And then you see 15th May, it says team busy with drafting. And then it says 10th June, what's DN, discharge? What is DN?
The discretionary notice. So it's a notice that is issued in terms of section 41 in brackets 1 of the rules of the PPSA.
Right. And it says sent to CI and EM. CI would be?
CI at the time wouldn't have been me, because I was on my wife's sick leave. It would have been maybe Mr. Dlamini, and EM would have been Ms. Mohaladi, if she was the one who was the EM.
Right. And then you see the entry, next entry says 7th July 2022, discretionary notice returned by CI with comments and inputs to incorporate and send back. Was there an acting CI whilst you were away, or would you have taken some time to look at it nonetheless?
No, there was an acting CI. That's why I was saying Mr. Dlamini and the late Mr. Mokosa were acting on my behalf at the time.
Okay. So when this is provided to me at the end of June, it is conceivable that because the discretionary notice was the CI, that's why it was in your office.
It wouldn't have been in my office, because at the time I was not at the office. It would have been in the CI's office or Ms. Mvuyana's office, because from the 7th of June last year up until August, I was on my family responsibility leave on my wife's ill health. I was not in the office.
Yeah, I'm not going to give evidence. We'll deal with that when Ms. Mbuyana comes to do that. So you have no idea what happened to the original investigative file in respect of the SARS unit report?
No, I should have, I would have, and then the file should be here. It needs to be found. But I'm surprised that you said that the original file is not here.
Well,
Because I even thought the documents that were sent to Parliament came from the original file. That's what I thought. I was made to believe as well.
Well, I've showed you, and if we go up to the top of this folder, which was provided to you, so I'm not going through. I mean, this investigative file was one of the documentation which Ms. Ibrahim provided you in advance of today. It's numbered 71 investigative file. Did you get documentation from Ms. Ibrahim, Mr. Mataboge?
Yes, I got documents yesterday or Sunday as well.
Yeah. And this was one of the documents that you did receive? I
don't remember, unless I didn't open all of them, but I didn't see this one. There were all other, there were emails, there were other correspondence and section 79s, but I didn't see this one. I'll have to go back to the document.
I'll ask Ms. Ibrahim to pass it on to you again so that you could have a quick squiz at it to make sure that I'm not misrepresenting that it isn't the SARS unit investigative file.
She did send me things. I'm not sure about this one. That's why I say I'll have to check it out.
No, I understand that. Right. When it comes to this investigative file, you would have expected the investigator to write into this file when subpoenas are issued, would you?
Yes, that's why I say on daily, when the activities are occurring, you write into the investigation diary. It's the life cycle of the investigation.
And would the chief investigator also write into the investigative file if something comes to his attention?
Yes.
Okay. And so if a subpoena was not delivered to anybody in respect of whom a subpoena was issued, for example, in the SARS unit case, we know that the subpoena wasn't issued to Mr. van Lochenberg. Would you expect that to be written on the investigative file?
When you say subpoena was not issued to Mr. van Lochenberg, I don't agree with you on that.
Sorry, my apologies, I misspoken. Let's start again. If the subpoena was issued in relation to Mr. van Lochenberg, it would be written on the investigative file. Would that be correct?
Yes, but not only to him. Yes. Not only to him alone, because there are other people to whom subpoenas are sent or were sent as well.
Let's put this more generally. In respect of anybody in respect of whom a subpoena is issued on a matter, that would be written onto the investigative file.
Yes.
If a subpoena comes back as not having been served on an individual, would you expect that to be written on the investigative file?
Yes, upon being received from the messenger or the person who delivered it. The moment we receive it, we then have to report.
You would have to report that on your investigative file. Sorry.
Yes, on the diary, yes.
Right. And what else do you write in an investigative diary? All the documentation you get, all the interviews you get, all the interviews you do, all the correspondence you receive, and what else do you put in there?
No, not necessarily everything, because if we were to put everything there, we'll have, like I was saying, hundreds and hundreds of investigation diary pages. Because when that's why I say we write the life cycle of an investigation. For instance, if you have received a report, you just know that you received the report in the investigation diary. if it's accompanied by a letter from the department, you say letter along with the report received. You don't detail on the content or any other, but we write into that, yes. But let's say if there are boxes and boxes that have got that are accompanying the letter, that have got documents, tender documents, you cannot not itemize and write them all in the investigation diaries. They would be appearing along with the letter.
Right. And when an investigator is appointed to deal with a matter, you would expect that all the information in the possession of the PP would be provided to that investigator.
Yes, because there should be a handover from whoever that dealt with the file if the person is there.
Well, let's assume it's a new investigation and there's information that comes in from the complainant and there's information that may be given directly to the PP. Would you expect the PP to provide the investigator with that information?
Yes, the information should be there to be given to the investigator, yes.
Now, in respect of the SARS unit report, the issue comes up, and we'll come to it in a little bit more detail, but let's just deal with it. Were you aware that prior to this investigation being opened, that Mr. van Lochenberg had communicated with the Public Protector's Office previously and had provided it with numerous documentation?
I was not aware at all.
Were you aware that there had been a closing report that had previously been done by Mr. Madiba?
Yes, that one I was aware.
And some of the issues Mr. Madiba had considered in relation to the SARS unit and had issued a closing report in October of 2017. Would that be so?
Yes.
Sorry, you might not remember the date exactly, but you were aware that in 2017 a closing report was issued.
Yes, I was aware of that.
And for purposes of the investigation in 2018 onwards, you had a look at this 2012 report, correct?
Which 2012 report?
The 2012 complaint. Mr. Madiba had finalized the closing report in 2017 in respect of a complaint that had been lodged in 2012.
I had no sight of the 2012 file as well as the report as you allude to now, because we were dealing with the new complaint. So you file we had. Those file we had no access because it had been filed away at our registry or archives.
So you didn't have regard to the closing report?
We didn't have regard to the closing report because the facts that were being raised in the subsequent complaint, in our view, were not related to the one that had been closed by Mr. Madiba. But at the same time, as an independent investigators, we did not want to get influenced by if there was any such closing report. We wanted to deal with an independent investigation of the allegations that were being brought out to us.
So you were not aware that that complaint also related to allegations about a surreptitious investigative branch known as the National Research Group, alleged to be carrying out clandestine specialized investigations?
That's why I said I was not aware. I didn't even look at the 2012 complaint and the closing report.
Okay. Let me take you to this closing report, which one finds at item 127.1, and we go to page 2543. Bundle F. 2543. So this would be the first time, Mr. Mataboge, that you see this report.
Yes, definitely.
Okay, so if I take you to paragraph 1.1.1 of the report. Wait, stop quickly. Stop, go back up. We see that it's a complaint lodged by Mr. Kaletso Manyiki on 21st February 2012. And I put to you what the complaint was about earlier. And it furnished the public protector with 19 names of alleged investigators and 30 names of unsuspecting civilians, politicians, and prominent businessmen in which certain allegations was made. Do you see that?
I see that, yes.
Right. In paragraph 1.1.1 of the closing report, it says the NRG investigative branch is headed by Mr. Johan van Lochenberg, the SARS manager responsible for special products, and operated under the stewardship of the acting commissioner, Ivan Pillay. Right. And the complainant's contention was that the appointment of investigators is irregular, as there are no employment contracts concluded between them and SARS, and neither are these appointments made in compliance with SARS recruitment processes, nor are the investigators operating from SARS business premises, but are home-based. Do you see that?
Yes, I see.
And if you go down in the report, this is not the same complainant as the SARS unit complaint. I accept that. It's a different complainant, correct?
I believe so.
Right. And if we go down at paragraph 1.2, it says the public protector elected not to investigate the allegations of illegal surveillance of politicians and business people, as it was felt that the PPSA is not the appropriate institution, nor has the required expertise to investigate illegal surveillance. As such, an investigation is focused on the allegations of maladministration and irregular recruitment process followed in the appointment of NRG officials. In your report in the PP's report in respect of the SARS unit, there was an investigation into illegal surveillance, correct?
I'm not sure. I'm not sure if you talk about illegal surveillance, whether it's a correct word. So I wouldn't want to comment on that.
Okay, I'm going to take you to the report in a moment, and then we can deal with that. And if we go to the reasons for the closing report, which you see on page 2571. It would be page 29, Shepo. Right? And it concludes, to just take you through the conclusions. It said that there was an investigation as to whether there were any irregularities in the recruitment process followed when SARS appointed employees of the National Research Group. Is part of the investigation into the Special Projects Unit, NRG, and High Risk Investigation Unit, which was also investigated by Advocate Sikakani. Right? You, in the conclusion of the SARS report, unit report, you had regard and relied on the report of Advocate Sikakani, correct?
That is why I had said to you, I did not have sight of this report, and then I didn't want it to influence any other thing that related to the new complaint. So I wouldn't want to comment on that. Thank you.
Now I'm asking you a different question. I'm saying when the PP, with your assistance and that of Advocate Mvuyani, compiled the SARS unit report, regard was had and reliance was placed on Advocate Sikakani's the advocate, what's called the Sikakane
Chairperson?
report.
Just pause, Advocate Bauer. Engathi ajam khulua. Advocate Mbofu.
Sorry. I didn't realize I was on camera. No, Chair. My objection is really that now Advocate Bauer is now really doing what she knows she's not allowed to do. These are some of the core issues to deal with the rogue unit, so-called rogue unit issue about the Sikakane report. So she can't put leading questions on that, unless if again she's basing it on some version that we don't know. When she says Mr. Mataboge places reliance on Sikakane, that's a very pregnant statement. It's a matter that is disputed on the one side or the other as to what extent were the other investigations, independent investigations relied on and so on. It's definitely a relevant issue, but the point I'm making is that it's a disputed question. So she's not allowed to put leading questions unless if she has a basis to do so. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer.
Chair, I can ask any questions, including leading questions. We must, every time Advocate Mpofu has raised and sought to restrict the questions I've asked, I've taken him back to the directive, which allows the evidence leaders to ask any question. But I don't want to get into a spat with Advocate Mpofu. I'm going to take the witness to the SARS unit report and pose the question again. And I didn't say that they only relied on the Sikakane report. So if it provides Advocate Mpofu with more comfort, let me phrase it this way. One of the reports to which you had regard, to which the public protector had regard in the compilation of the SARS unit report included the Sikakane report. Would that be correct, Mr. Mataboge?
Yes, that is correct, Advocate Bauer.
Okay. So let me go back to the closing report, if you've got that out of the way. No, sorry.
PG1.
No, go back to the closing report, 127.1, page 29. Let's just close this out. So I accept, Mr. Mataboge, that you say that your evidence here today is that you didn't have regard to this closing report. But just for the sake of the members and while we're on this report, let me just take them through what the closing report had found, right? And I'd ask you for your comment on anything if you so wish to comment after I've told him what the reasons for the closure were as for the report. So if we go to page 5.1.2, the closing report, Advocate Sikakane in his report recommended to SARS that the activities and functions of the unit must be specifically investigated by the Inspector General. SAPS has also tasked to investigate the matter, which the National Prosecuting Authority head, Advocate Sean Abrams, when briefing the Portfolio Committee on Justice on the 28th of March 2017, stated the investigation of the so-called rogue unit at SARS is yet to be finalized. And then comes to the conclusion that's reached in this report. We cannot pursue this matter any further as it is in front of the Office of the Inspector General of Intelligence, and the NPA is in the process of finalizing this matter. In 5.2, it says whether there were irregularities in the process followed in the dismissal of Mr. Piega. Do you know who Mr. Piega is, Mr. Mike Piega, Mr. Mataboge?
I got to know that he's one of the former employees of SARS, I believe.
Did you consult with him during the SARS unit report?
No, I don't remember.
Okay. And in the closing report, it's found that the allegation as to whether there were irregularities in the process followed in the dismissal of Mr. Mike Piega is unsubstantiated, as due process as followed by SARS and a disciplinary hearing was conducted by SARS in respect of his dismissal. Go down further. Mr. Piega also appealed the decision of the disciplinary committee, and subsequently, after considering all argument filed, the appeal chairperson, R.J. Mabuza, found that the appeal to be without merit and dismissed it. Are you aware of that, Mr. Mataboge?
I wouldn't be aware of it, Bawa. I said I didn't have sight of the report nor the file itself.
No.
I wouldn't be aware.
I'm just talking about the finding of the appeal chairperson, not necessarily the conclusion in the report.
I will not be aware of that as well.
And then it comes to whether there were any irregularities in the transfer of Mr. Keletso Manyiki from the SARS head office to Nelspruit. And the conclusion there is that the allegation as to whether there were any irregularities in the transfer of Mr. Keletso Manyiki from SARS head office to Nelspruit is not substantiated, as SARS merely followed Mr. Manyiki's request to be transferred and thus approved his request. Further, SARS, in fulfilling its obligations in terms of clause 464B of the FTSS agreement and in consultation and agreement with Mr. Manyiki, secured a suitable position for him in the debt management division in Mpumalanga. And so in conclusion, Mr. Madiba finds, having considered your matter, evidence submitted on the record is against this background, and to this end that the conclusion with respect to your matter be reached, forthwith is a conclusion of same thereof. And it then says, kindly take notice that in view of the aforementioned reasons, this matter will not be, I think it means pursued any further by this office, and wherefore we are considering closing the investigation in question, and he is then given an opportunity to provide further information to respond to the closing report. And then it says that this notice is confidential and the contents mustn't be disclosed, and it's signed by, go down, it's signed by the senior investigator and the chief investigator in October of 2017. Right? Now, if I take you to the SARS unit report, Mr. Mataboge, as a matter of procedure, if a report is closed by anybody other than the public protector, then the public protector is entitled to review such report. Would that be correct as a matter of procedure?
Yes, that is correct.
And that happens at times when the complainant lodges an appeal, for example, or provides further evidence, and it comes up to the public protector. She may very well have a look at it and come to a different conclusion. There's nothing untoward about that. Would you agree?
Yeah, that is correct. That is correct.
Yeah, just hold on a second. Yeah. Just give me so I want to spend, and I'm probably going to start and finish this with you tomorrow morning. I want to take you through some pertinent aspects of the SARS unit report, and I want to at the outset say this to you. I'm interested, and I'd like for you to share with the committee the process that was followed and not necessarily the outcomes. So the conclusions of fact that is reached, for example, whether or not the SARS unit did or did not do illegal work. I'm not wanting to take you through the substance of the findings of the report, but to explore the process in the context of the motion. Do you understand what I'm saying, Mr. Mataboge?
No, I don't.
Right, so I'm not. Yeah, okay, I knew that came out badly, Advocate Mpofu. Let me try it again. I'm looking at the process that was followed in the compilation of the report. And so my questions are going to be geared towards the process that was followed as the report got compiled. Does that make better sense?
Yes.
I'm not going to delve into.
No, before you can Mr. Mataboge respond as well, then you can add. Mr. Mataboge, the question is towards you.
Chair, if I understand it correctly, it means the end product, not the whole journey of an investigation. Am I right to understand it that way?
No, I'm talking about the process of investigation and not necessarily.
Which is the journey that I'm referring to.
Yes, the journey of the investigation and not the findings of the investigation as such.
Yes, yes. If that's the case, I understand you, Advocate Bauer.
Do you also agree to that, Jenny, Advocate Mbofu?
Yes, I do understand, Chairperson, but it looks like we've also come to the end of the journey right now.
Okay, I want to
Thank
do
you,
one.
Advocate Bauer.
Well, let me use my 9 minutes productively, but I do know that Mr. Mataboge has constraints and I won't keep him. Just to put this on record, it starts with an anonymous whistleblower complaint in October of 2018, and then we have a complaint lodged dated the 8th of November by Mr. Shivambu, which is stamped the 9th of November. That's what starts off the inquiry. Would you agree?
Yes, I do agree, Advocate Bauer.
And I'm not interested in the identity of the anonymous whistleblower. So let me put that up front with you. But I am interested in 2 things about the anonymous whistleblower. Did you have a meeting with the anonymous whistleblower?
Yes, under normal circumstances, we would, because as I said, our process indict us to log the issue and confirm the issue for investigation. So I'll have to check my records. In that, we'll be discussing that tomorrow.
Okay. So we have an email on file which may assist you, where the anonymous whistleblower says he's not residing in South Africa, but he would be in South Africa in December and an appointment scheduled. And I have a reference that this is an email dated the 22nd of October, 2018, where he indicates that. And my next question, which you may want to check, is whether indeed such a meeting had taken place with the anonymous whistleblower. And please understand me, Mr. Mataboge, I don't want any information that would disclose the identity of the whistleblower. I'm mindful that there's an obligation on your part to protect it. I just want to know whether such a meeting had taken place. And the second leg of that argument is whether documentation and information had been provided to you by the whistleblower.
That I understand, Advocate Bauer. That is clear.
Chair, I know we have a few minutes, but this would be a convenient time for us to adjourn.
Yeah.
Well, if we get that bonus of minutes from you, which is 5 minutes, I will not object. We will pause here, colleagues, for today, and then we will resume tomorrow with Advocate Bauer. And the time, just to remind everybody, because we are going to end at 1 o'clock tomorrow. So we'll start at 9 and not at 10. You are dutifully reminded about that. We'll pause here. Thank you, Mr. Mataboge, for the start of the session with you. You did not share, maybe you can share that, your secret of how you change your sitting. Just share with those that might need that in future. What did you do to project it the way it in the afternoon it got better?
No, I have a beautician in Parliament who positioned me, who put me up for makeup, Chairperson.
Thank you, Mr. Mataboge. Well appreciated. We'll pause there. Some other people might need that. Thank you.
Yeah.
So, tomorrow at 9.
Yeah.
Recording stopped.